Thank you so very much for being back. If you just joined us, you're still on to Enterprise Morning, reaching you from Enterprise Television. Let's get to our conversation for today. 11 governors from the People's Democratic Party (PDP) have approached the Supreme Court to challenge President Bola Ahmed Tinubu's authority to suspend a democratically elected government structure in Rivers State. The suit also contested the president's declaration of a state of emergency in the state and the appointment of a sole administrator to oversee its affairs. President Tinubu on March 18 announced a 6-month suspension of Governor Simenalayi Fubara, Deputy Governor Ngozi Odu, and all elected members of the Rivers State House of Assembly. He appointed retired Vice Admiral Ibok Ete Ibas at the state's sole administrator during the emergency period. The National Assembly backed the president's action in response to the 11 PDP governors from Adamawa, Enugu, Osun, Oyo, Bauchi, Akwa Ibom, Plateau, Delta, Taraba, Zamfara, and Bayelsa filed suit at the Supreme Court. The suit filed through their state attorney generals is based on 8 legal grounds. They asked the court to determine whether the president has the constitutional power to suspend elected governors and legislators and replace them with an unelected administrator under the guise of a state of emergency. Specifically, they cited various sections of the 1999 Constitution, including Section 12, 52, 176, and 180, 188, and 305, arguing that the president's actions were unconstitutional and violated principles of federalism. They questioned the legality of the suspending the elected officials without due process and whether the president can unilaterally replace them during an emergency rule. I still have with me Barrister Tunji Abdulhamid. Thank you so very much, Barrister, for being here.
Thank you for having me.
All right. Yes, very well said. Barrister, I'd love to believe you are the best person to tackle this matter. Number one, you are, this is your area of experience. Maybe you help us fleshing out what exactly it is the state attorney generals of the PDP states have gone to contest with the apex court, and if it would hold water, if it's ever possible, it would hold water. Or this is just but another textbook, practice or exercise.
Yeah, I think I want to commend the governors of the PDP, the 11 governors. They've done the right thing. They have taken steps that will likely save our democracy in a way, what the National Assembly cannot do, because the National Assembly ought to have saved us from this embarrassment. Like I said, I may not be correct. I may be correct because today in our law, the laws are interpreted differently. In fact, unfortunately, even the courts, with due respect, who are supposed to even sometimes do the right thing, will just dodge or do something else that is not proper. You see, the law allows. And I like the way they do it. It's not if it's taken by the governor of Rivers State as an individual, the matter will start from the High Court, and that will cause a lot of delay. As it is today now, the matter is going straight direct to the Supreme Court, because any issue between the state and the federal government can be argued by the state by the Supreme Court direct, as the Supreme Court has the jurisdiction to entertain it as a court of first instance. So the Supreme Court is the last court. So once the Supreme Court decides, there won't be a waste of time. I do not expect that this matter will take long. It must not. If things are done the way it should be done, it may not even take more than up to a month to be decided. If things are not, because what they will do is just to file a objection application. It's been filed already. It's by way of rejecting someone. The other party will file a counter affidavit, and then it will be adopted, and judgment will be delivered. So for me, I think they've done the right thing. What are they asking for? I've always maintained that the president of the federation has no power to suspend any elected officer in a state, because having regard, just like what they've asked for, they've asked the court to determine whether having regards to Section 1, Subsection 2, Section 5, Subsection 2, Section 176, Section 180, Section 188. And Section 3005 of the Constitution of the Federal Republic of Nigeria as amended, the governor and the president has the power to suspend an elected government or an appointed a sole administrator. They've also asked that having regards to Section 4, Subsection 6 of the Constitution, Section 11, Subsection 4 and 5, Section 105, and the Section 305 of the Constitution, whether the president has the power to do that. They are saying, you see, what does Section 1, Subsection 2 says? Section 1, Subsection 2 says that look, in summary, I'm paraphrasing, that the Federation of Nigeria shall not be controlled, nor shall not be governed, nor shall people or individual or group take over control of any of the federation or any part thereof, except in accordance with the provision of the Constitution. And if you look at our Constitution, Section 5, Section 2 also say that look, executive power of a state is vested in the governor and can only be exercised by the governor, either directly by himself or through the deputy governor or his commissioner or any other person he gives the power to. That's what the Constitution provides. Section 176 is saying that the government shall be the chief executive of that state. So there's nowhere in our Constitution where an administrator is being considered or even make reference to. There is nowhere in that Constitution. So what we have seen today regarding administration is an aberration. If you also look at Section 180, Section 180 is highlighted circumstances in which a governor will cease to be a governor. In other words, if he dies, if he's removed, if this and that happen, if tenure they have 4 years, if the tenure expires or something, those are the circumstances when they can be they will cease to be a governor. Not that there is no where it is stated that when the state of emergency is declared, the president is suspended by the president. It's not stated. Section 188 also provide the means of removing a governor or his deputy. It's stated there. And we also have a Section 4 Subsection 6 that gives the legislative power of the state to the House of Assembly. So in other words, legislative power of the state is vested in the House of Assembly of the state. And those House of Assembly have been suspended by the governor and by the president today. And the Section 11, Section 4 and 5 also goes further to say that look, where the National House of Assembly of that state is unable to sit, the power vested in them shall be exercised by the National Assembly. And the section also provided that the National Assembly shall not have the power to remove an elected governor. It's clearly stated there. So and they say the way and manner a house can be dissolved is stated in Section 105 of the Constitution. In all these sections we have mentioned, I did not see anywhere that is stated that the house can be dissolved upon declaration of emergency, that the governor can be suspended upon declaration of emergency, that once an emergency state of emergency is declared, that because you see one of the excuses given in the broadcast by the president was that there is no that the Supreme Court said that there is no governance in Rivers State because there is no House of Assembly. I beg to disagree. There is no House of Assembly in Rivers State, and they are issuing notice. It's even contradictory because the same president make allusion to the fact that they want to impeach the governor. They've issued notice of impeachment. Where did they? If they are not sitting, where was the notice issued? Who issued the notice? The same House of Assembly that they say does not exist in Rivers State also issue a warrant of arrest against the state INEC chairman. The same what's it called? House of Assembly that we are told by the Supreme Court and the president that does not exist in Rivers State. Also, they gave the governor 48-hour ultimatum to represent budgets and to also represent commissioners. So where were they doing all this?
But sorry to interject. The president equally stated very fundamentally the bombing of the Rivers State House of Assembly as one of the reasons he cited amongst many that contributed to the state of emergency. But that is factual, isn't it?
It's not factual. Is that what I was explaining now?
Yes, but the house, but the Rivers State House of Assembly was bombed. It was demolished by Governor Siminalayi Fubara.
When was it demolished? When was it demolished? It was demolished one year ago. And after that 1 year, they've been sitting somewhere else. The notice of impeachment was issued how many months ago? 2 months ago, or how many months ago? The warrant of arrest against the chairman of the electoral committee was issued when? Was it not just 2 months ago or 3 months ago? The ultimatum to the governor, was it not issued from few months ago, a month or two ago? And when the House of Assembly was born when? Over a year ago. And since that time, they've been sitting. They've been issuing notices. They've been issuing, they've been passing resolutions. They've even passed law, abuse into law. They've passed bill into law. They've fettered the power of the governor. So what are we talking about? What are we talking about? That's why I say I bet to disagree with the Supreme Court. The Supreme Court is one of the reasons why we are where we are today. They are always begging the issue. They are always trying to bend, and you can see the word has been given recently. A party came to you for a resolution. They say it's a party affair. Go back to the party and resolve it. Party they've come to the court because they cannot resolve it. So I expect the court to look into it and say, look, since that you are complaining about infraction of the constitution or of the law of your party, and you are not able to resolve the issue, the only person who can resolve it is the court.
But don't you think, Barrister, the same people who might be questioning the power of the court in political issues, especially party politics, will be the one to come against the court if the court determines who becomes what? In the case of the secretary of the PPDP, which of course was an issue between Ude and Iwanyan.
That is the point I'm making. The matter they are bringing before you is not just for you to just sit down and say, you look at the paper file before you, you look at the law, you look at their own law too, and make finding on that. Is that not how to go about it? It's not as if you just sit down in your office and say, we have decided to appoint Mr. Soto as your secretary. No, you look at what they brought before you. Look at their constitution. Look at whether or not there are true infraction of the constitution. Whether or not anything has happened in that regard, whether you have followed the law or not. So if the law is not followed, you have the right to say, look, you have not followed the law. This is not the way to remove somebody. This is not the way to do this and that. You did not do that. You said they should go back and settle by themselves. They said they cannot settle. That's why they were in court. If they can settle by themselves, would they come to court? You say it's a party affair. Go and decide it by yourself. When people are not ready to cooperate.
Yes,
but for example, I say go and settle party matter with Mr. Wike. Did you think he would listen? Yes. The people who are blaming Atiku and PDP at that time now know the kind of person Mr. Wike is now. That whenever he's having issue with somebody, there's no way he can settle it, except he wants to settle it by himself. So it must be him that will determine whether or not settlement will take place. If he's not ready to settle, nobody will settle. So what are you talking about? So if people are not ready to settle, you said they should go back and settle. So let me just say what I'm saying. Yes. The point I'm saying is that, look, it is not correct that our assembly in Rivers State were not in existence at the time the pronouncement was made by the president. They were in existence, and I'll give you facts. They were making pronouncements. They were passing resolutions. They've even issued, in fact, a week before that proclamation, or for days before that proclamation, they issued notice of impeachment. Where were they sitting? If there's no House of Assembly. So for me, it's a deliberate attempt to just take over Rivers State. That's what I see, and that's why you see whatever step that's been taken by the administrator will not be listenable to anybody, because he has no book that is following, no law. He's just there on his own and at the mercy of the president, doing whatever the president wants him to do, as if we are not in the country that ruled by law.
But
the law is clear that the executive of the state is vested in the governor, and the only governor is the chief executive officer of the state. And the mode of removing a governor it has been stated in the constitution. It is not stated in any part of the constitution that says where a state of emergency is declared, the governor shall be suspended. It's not stated that the elected officers, elected political officers shall be suspended. There's nowhere in that constitution. It's an aberration. It's tyranny. As far as I'm concerned, I particularly look at section 1, section 2 of the constitution, which says that no federation of Nigeria or any part thereof shall not be governed or controlled by any person except in line with the constitution of the Federal Republic of Nigeria. How do we determine a governor? We elect. That's what the constitution says. For you to be a governor of a state, you must be elected. Who elects this administrator in place today? And that's why you see all the steps that is being taken is being challenged by people. People are worried. He wants to appoint a administrator. They've gone to court, and it's been stopped for now temporarily. He wants to present budget. People are worried. Why will he present the budget? How did you come about the budget? He wants to appoint. He remove political officers. Whatever. People are asking questions. He cancelled all the contract entered by the former governor. People are asking questions because it's not based on law. So people will continue to ask questions as long as it's on seat.
Yes, but
because it's all the things that we'll be doing, we have no basis under the law. No law recognize that.
Yes.
I cannot act based on any law. He's just acting based on the interest of the president. So in other words, whatever the president decides is the law.
Yes,
as far as the is concerned.
Yes, you might call this an aberration, of course, which it is what it is. But how come, barrister, I would love you to help me explain this further. If you are in the field, you understand the law, the rule of law, because it's your area of forte. The Senate president is a barrister, is a lawyer who has been there for so many years. So many parliamentarians who voted for the state of emergency, most of them are lawyers. How come these people are oblivious to some of these facts that you have stated here?
Because they don't know.
They don't know?
Yes.
They don't know?
That Mr. Wike, listen to me now.
Yes.
It's not in dispute that the Senate president went to law school and went to school. Did he practice? Was he in the system? Does he know anything? It is also on record that Mr. Wike he went to law school and he graduated and he passed. After his graduation, where did he practice? There is difference between reading practical book and practicing. You do not do anything. Rather than going to school and obtain certificate. Funke Akindele went to law school, although he didn't go to law school. He's also a lawyer. Can you ask her to come and interpret the law? Will she be able to do that? With due respect to her. So you see, when we say lawyer, there are people are just lawyer by name. They are not lawyer. They don't have the knowledge of the law. That is with due respect. They don't have the knowledge of the law. They are only called lawyers. So they are called lawyers because they went to law. They attended university, obtained a LLB, and went to law school, obtained BL. Some even went further to do LLM with his master. That does not make them a lawyer compared to people who are in practice or people who are walking the talk. You can't compare the knowledge of law with those people. And again, let me even tell you, they are not even looking at the law at the National Assembly. They know the law. They know about the law. Don't they know that when they say 2/3 of majority of members, don't they know that you cannot determine 2/3 by false voice for false votes? They know now. It's not that they don't even know more of these things that we're talking about now. There are some of them are even elementary that they know. Mm-hmm. But because they have a mindset, they know why they are going. They will pretend as if they don't know, or they will say this is the way we see it. So for me, don't compare when you talk about people who are lawyers or who are practicing lawyers or who know the law. Please, with due respect, some people are just certificate holder. They are just certificate holder. They don't have the knowledge of the law. They have the certificate with due respect, but but when it comes to knowledge of the law, they don't have it. Mr. Wike, the Minister of FCT, who is a bencher, was not awarded that bencher just because of his practice. He was given because of his contribution when he was governor. The money is spending to build a law school, build that, and that was the reason it was awarded. Tomorrow, people will come and say, once you are a bencher, that means you have contributed more, or you have a knowledge of the law in a high level. No, some is just because they have certificate and they have the opportunity to do certain things. So for me, don't say they are lawyers. Some of them are yes. I'm not disputing that they are lawyers. They are lawyers. You can't compare the knowledge of Mr. Falana and other who are SAN, who are in practice with that of Mr. Fabio, who has left practice for how many years. Since I started practice, I know him as a politician, as a commissioner. Since before I started practice. Since I started practice, and even before he became a commissioner, he was into telecom services, not law. He was into telecom. He was into telecommunication services. He had his office at Obalede at that time. I know. 1 3-bedroom flat or 2-bedroom flat like this.
Really?
He was doing telecom. Emis or what? I can't remember the name of the telecom service again. Is it Emis or something? So you don't compare those kind of people with people who are truly sitting down and reading law every day and are going to court and determining the issue. So for me, it's not about them not even knowing the law. It's about them not ready to do the right thing. It's about them playing politics. And that was why they did not allow the vote at the National Assembly to be by way of either electronic or any other means. That's why they use the voice vote. How can you determine 2/3 of a voice vote? And you say you have a register attendant. I can register and not vote. I can register and I will not vote during voting. So the fact that my name on the register does not mean I voted in favor of it. So for me, it's about people not ready to do the right thing. It's about playing politics. So the issue of this Section 305, if it's not challenged, and this is a challenge to the Supreme Court as well. Otherwise, if they say otherwise, they'll be setting wrong precedents, and will one day have a president that will suspend all the governors or half of the governors of the state in the name of Section 305. If this is not checked, so I don't want the Supreme Court to come by way of technicality. Let them address the issue, so that it will lay to rest. The issue of technicality should not come. The Supreme Court is not only a court of law; it's also a court of policy. That's what they tell us. So if they are truly a court of policy, they will ignore technicality and look at the issue and address it.
But how much of these days? Yes, Barrister, how much of that?
Let me finish. What I've seen them do these days is to adopt technicality and create more confusion. You can see what is happening in the Labour Party. You can see what is happening in the PDP. Nobody can tell you this is secretary of the PDP now for now because it's not clear. Labour Party, nobody can tell you this is chairman because it's not too clear. Everybody is interpreting the way they like. So for rather than them come clean and say go and settle, and they say go and settle by yourself. It's a party affair. Party affair, yes. And if they can settle, will they come to court? They will not come to court if they can settle. So as far as I'm concerned, the court is there to resolve issues when people don't agree, particularly when it has to do with breach of law or breach of constitution of a party. I expect the court to be able to attend to it, but they are saying the court has no jurisdiction to look into internal affairs of the party. Internal affairs that cannot be resolved, what will happen to it? It will continue to linger. Is that what they are saying?
Yes, but Barrister, how much of that avoidance of technicalities can be possible when we know too very well that the judiciary under President Bola Ahmed Tinubu is allegedly hijacked by those in power? Just yesterday, the FCT minister took the House of the members of the River State House of Assembly who are on his side to the UK for whatever meeting they were there for. Of course, we all know it is directly related to what's happening in River State and the future of their position. Now, do you really think this technicality we are hoping would not be part of the things the Supreme Court would use to place their bait would be avoided when we know that those in power have totally taken over the judiciary and control what they do, allegedly?
Yeah. No, it's allegedly you have said it. Allegedly they're taking over the power. Allegedly. But and that's what I'm saying. The court should also act in a way that people will not say truly you have been taken over. And that's why I say Supreme Court, being a court of policy, should not be resorting to technicality in whatever form. In whatever form. Whatever a matter is before you, address the merit of it. Ignore the technicality of it. Address the merit. Because you are not only a court. Apart from outside the Supreme Court, you can't go anywhere again. So you must use that opportunity to resolve the issue. So for me, the point is that you see, except we are deceiving ourselves, the judiciary is not standing firm. It's not standing firm, and that's why you will see a presiding the president of the Court of Appeal being inaugurated as a chairman of board of trustee of a group, of a club,
yes,
wherein we have lawyers as members, wherein we have politicians as members, wherein we have litigants, people that will be having cases in court, in his court or our court, as members. What will happen when those people have pattern before the court of appeal? How will it justify that there was no any collaboration? We are in this country when a senator came up and said, "I want to apologize to my wife that I infiltrated into her private issues affair because I begged her for my colleagues who needed assistance while she was a judge." So those are the issues that's not making people believe in the judiciary, and nothing has happened to date.
And how can we correct that? Can the NJC correct that? Is it ever possible?
Who is the NJC? Is NJC is not headed by the CJN? That has also been alleged or been biased, allegedly. That has also been alleged that he's working for he's been captured. Is not part of it's not the head of the NJC. The president of the court of appeal is also part of the NJC. What are you talking about? So you see the system is the way it is, and we can only have it resolved if people are going to be upright. There's no sincerity. For me, the state of emergency in Rivers State is unknown to our law. The steps being taken by the administrator is unknown to our law. Has no any basis under our law. There is no any traces of how it should be happening. The emergency situation envisaged under section 305 does not envisage the suspension or removal of any elected officer or appointment of an administrator. What they envisage is that, look, the issue of if you look at that section 305, all the circumstances that can lead to what's it called, state of declaration of state of emergency has to do with insecurity or lack of peace. What they expect them to do is to provide more security to ensure that peace is restored, not to remove the existing government. Suspension of existing government is in conflict with the constitution. And I'll be waiting for the Supreme Court to say otherwise. I'll be waiting to see at that day. I'll just raise up my hand that Nigeria is gone.
Wow.
Then that means we have handed over our country. We have handed over our country to individual to do it the way they like. Because once that is confirmed, that the president has the power to do that, I tell you, most states will be declared. Even if this president not do so, some other people will come thereafter and will rely on this and start to suspend all government they seen as opposition or that's not doing well that's not supporting that they see as not supporting their interests. So it's going to create a dangerous precedent. And that regard, I expect Supreme Court to be more not to rely on technicality in this case. Look at the merit of the case, whichever form. I'm talking about technicality not because the Supreme Court can come and say what the governments are saying are just mere suspicion, that nothing has happened to them, that nobody has removed them, and they've not been sacked, because they cannot come directly and say they are fighting for Rivers State. They are saying that they will say, "What is your locus?" But they are saying it like a public interest litigation now for the court to determine that, having regard to this section, whether the president can suspend any governor. The court can come and say, "I will not be surprised." They come and say, "This is suspicion. It's not you cannot rely on mere suspicion, speculation, and file a case in court. That the incident must happen. There must be reasonable course of action." They can tell you that there is no reasonable course of action. So that's why I'm saying they should not go by way of technicality. They should rely on they should look at the merit of the case and lay the matter to rest, and so that everybody will know, because there is no other law that regulates what happened after a state of emergency has been declared. This is an opportunity for the Supreme Court to set that standard so that people will follow it.
So very, very true, Barrister. The onus right now is on the Supreme Court, the apex court, to do the needful so as to avoid what people have concluded as state capture in Nigeria, where people in authority are directly in charge of different arms of government and direct their affairs and what they do. We just hope it will not be our case in Nigeria, because just like you said, the Barrister, it's very important that we do not set a wicked, dangerous precedent for Nigeria that would, of course, consume every one of us and render everyone, incompetent in a country like ours. Thank you so very much, Barrister. We truly do appreciate your insight today.
Thank you for having me. It's my privilege to be with you.
Thank you so very much.
Thank you.
All right, that's just the time we have. I'd love to believe you enjoyed our show, and most importantly, the insight and the clarification that has been made possible by Barrister Tunji Abdul Hamid. I enjoyed it. I love to believe you will also. But please, you can read up on everything we've discussed when you visit us at enterprisetvnews.com, and equally, you might rewatch if you may, and when you visit us at Enterprise TV7. That's our take for today. My name is Henry Gubike. Thank you for watching. We'll see you tomorrow. Bye-bye.